Dr. Kate Elizabeth Brown is an assistant professor of history at Western Kentucky University. She specializes in American legal and constitutional history, the early republic, and early modern English legal history, which I had to study for a while too. Her latest book, Alexander Hamilton and the Development of American Law, was published in 2017 by the University Press of Kansas. Dr. Brown has published articles in the Law and History Review and the Federal History Journal. She is also the recipient of numerous awards and fellowships, including a National Hamilton Scholar Award, a James C. Fries Fellowship, and a fellowship at the Gilder Lehrman Institute for American History. So please welcome Dr. Kate Brown.
Hello, everyone. Thank you so much for being here. I'm delighted to be here, and just being in this room, it's so extraordinary. So thank you for inviting me. Today I am going to talk about Alexander Hamilton and the Development of American Law, which is also the title of my book. And I think I'm going to start by reminding you of just what I remind my students, which is that we think that we know Alexander Hamilton really well. And this is even more so in a post-Lin-Manuel Miranda world. We know him as a statesman, as the first Treasury Secretary. We know him as a party chief, the head of the Federalist Party. And we know him as George Washington's right-hand man during wartime and then afterwards. But today I'd like to convince you to think of Alexander Hamilton first and foremost as a lawyer. And during his day in the 18th century, he was known as one of the best lawyers in the early republic. And part of the reason for that is because he used law day in and day out in his professional career. So much so that I can make the argument here for you today, as well as in my book, that, well, really two things, two parts to my argument. First is that Alexander Hamilton used law as a tool to accomplish his policy objectives, things that we're familiar with already. And then the second, more important part of my argument is that Hamilton had an impactful role in the early republic at developing American law, both during his lifetime as well as beyond, in the 19th century and beyond. So I want to convince you of that today, and to do so, I've selected 3 different episodes from Hamilton's legal career to talk with you about. The first will be Hamilton's early private practice after he becomes a lawyer and he's working the streets of New York. And then the second episode will be as the Treasury Secretary. And finally, we'll look forward in time and we'll think of Hamilton's legal legacy after his death. How did other jurists and lawyers think about Hamilton and his jurisprudence? So before I jump into the first episode, I do want to remind you that in the 18th century, when Hamilton was becoming a lawyer, he did not apply to a Harvard law school. He didn't take the LSAT, and there's no such thing as a 1L, 2L, or 3L at the time. Instead, if you wanted to become a lawyer, you basically had to teach yourself. So when Hamilton decided to leave the army after the Battle of Yorktown, he goes back to his adopted state of New York, where his young family is waiting for him, and he goes and he raids a friend's library, and he pulls out all of the legal treatises he can find, like Blackstone's Commentaries on the Laws of England, and any statute books he can find, English case reports. A lawyer who is doing this process, known as reading law, might also go to a local court and watch law unfold around them to get the feel of the process. And then when the time is right, when you feel ready, you go before the individual courts in which you want to practice, and you're examined by the court. And once you get the A-OK, you're admitted to practice before their individual bars. And I think it's a testament to Hamilton's brilliance, because he's a really smart guy, but also his drive, that he can leave the army in 1781 and already be admitted to practice in New York State courts by 1782 and at the latest 1783. So he was a really quick study. And with that in mind, let's turn to our first episode of Hamilton as a lawyer in private practice. Now, Hamilton, when he hung out his shingle and decided, I'm going to practice law in New York, the kinds of clients he took on was significant, because he decided that he was going to represent the very unpopular loyalists who remained in New York State. Now, loyalists, of course, are people who, during the course of the Revolutionary War, they decided that they were either going to remain loyal to the crown, or maybe they just weren't patriotic enough, so they're labeled as loyalists. And during the course of the war, New York State does everything it possibly can to harass loyalists and to deprive them of their due process of law. And so Hamilton makes it his mission to try to do something to restore that legal process to these loyalists. So before I jump into how Hamilton goes about doing this, with this focus on rights and liberties, I want to tell you a little bit more about what's going on during the war and after in New York State. Because the state is divided ideologically as well as geographically. And this is aided by the fact that during the war, the British Army occupies New York City for most of the Revolutionary War. And this has the effect of sending people out of New York if you want to support Washington's army and if you want to support the patriotic cause. And it has the effect of sending people into New York if you want to seek the protection of the British Army. Now, while all that's going on, New York State's legislature is passing laws that are targeting loyalists. And they're harassing them with these laws, they're denying them legal process, as I mentioned, and in total, there's something like 30 or so different anti-loyalist statutes that New York State passes. But for us today, I want to talk about 3 of them. Because these 3 were really important, not only in Hamilton's post-war practice, but they were really effective. They got the job done of harassing loyalists. So the first one, passed in 1783, is the Trespass Act. And in order to understand why the Trespass Act was so good at harassing loyalists, I invite you to think about something I said a moment ago, which is that during the war, people are fleeing into New York and leaving New York. So the people leaving New York City are leaving behind all of their real property. And the people coming into New York, well, they're coming in with what they have in their wagon and the clothes on their back. And so they're entering this city that has been partly abandoned, and they're encountering all of these storefronts that are empty, and brew houses and taverns and inns and warehouses, etc. Now, under English law, which has adopted principles from a general body of law called the Law of Nations. So under English law, if you, during wartime, are a refugee and you want to use abandoned property, you can just go and ask the commanding officer of the occupying army for permission to use that property. And so long as you don't destroy it or something, then you should be okay, so that after the war, you won't be on the hook for any kind of liability for trespassing on someone's property. So that's what it's supposed to be like. What the Trespass Act does, what New York State specifically does in this particular statute, is to deny that military permission defense to anybody who sought permission and used property that wasn't theirs during the war. So now you have all of these people on the hook for damages after the war because of the Trespass Act. The next statute for us to consider is the Confiscation Act. And this amounted basically to a bill of attainder, where New York State, in the statute, lists by name a number of high-profile loyalists, and the statute calls them enemies of the state, and says, as such, the state can take your property. This is not a taking with due compensation. This is just totally taking of your property for use by the state. And the language of the statute is broad enough such that even if you weren't labeled by name an enemy of the state, you could later be deemed an enemy of the state and have your property confiscated from you. The final act to note is called the Citation Act, And this act messes with contractual rights because it allows a debtor class that tended to be patriots to retroactively change contract terms with their creditor class who tended to be loyalists, such that the debtors could get off the hook for paying the sums of money owed in contracts. So these sorts of statutes are on the books. Hamilton knows that they're effective and they're really well written, such that it's hard to find a way to attack them directly. Nevertheless, Hamilton decides, as a newly minted lawyer, that he's going to take on loyalists as clients, and he's going to take on the challenge of defending them against these kinds of laws. And we know that Hamilton knew that this was an uphill battle, because a decade later, when he's chatting with President George Washington, it's in 1795, he writes to Washington about this experience. And he says to Washington, I knew this was tough. I knew it was tough because, first of all, there's only a handful of lawyers in New York who are even willing to take on loyalists as their clients in the first place. And the second thing is that these laws were really effective. So I couldn't make a sort of head-on challenge to them. I had to, in order to get some kind of justice for my clients, I had to do a circumventing approach. Try to mitigate the effects of the laws or get around them, if at all possible, in order to try to get justice for my clients. So he ended up developing a multi-pronged legal strategy with the idea in mind, how can I circumvent these laws so that my loyalist clients can get some degree of justice and legal process? So this strategy, as I said, was multi-pronged, and it also was deployed depending on who his client was and what the circumstance was, as you might imagine. So the very first of Hamilton's, I think he was most proud of this prong of the legal strategy, is developing new defenses to counteract the Trespass Act in particular. And remember that the Trespass Act is that anti-loyalist statute that denies the plea of a military justification during the war. So Hamilton develops two new pleas, two new defenses, and he calls them the plea of the Treaty of Peace, which is out in 1783, and the plea of the Law of Nations. And basically, it works like this. Hamilton goes before one of the courts of New York City, the mayor's court, and he argues that law has a hierarchy. There is higher law and there is inferior law. And it just so happens that the Treaty of Peace with Great Britain and the Law of Nations, those are higher laws than the statutes of New York State. And that matters here because both of those higher laws, the treaty and the Law of Nations, give to my client access to the military justification defense. So because of that, that should trump New York State statute, and therefore my client should be able to have a defense against this charge of trespass. Hamilton sees some success with this. Now, it's not full-blown success. For example, this mayor's court of New York, they do not agree with Hamilton that the Treaty of Peace has anything to do with a military justification defense. So they throw that out. But they do agree with Hamilton that higher law exists and that higher law trumps the inferior law. But they're not willing to go to the extent that we might expect today, which is to strike that inferior law down as null and void. That's too extreme. So instead, taking Hamilton's premise that the Law of Nations is higher law than the New York State statute and that it provides a military justification defense, the court does some slippery maneuvering where it says, in the New York State statute, the Trespass Act, the New York State legislature does not explicitly say that they mean to contradict the Law of Nations. And because it does not say that, we are going to allow that plea of military justification provided by the higher Law of Nations to prevail. Your client has access to it, and we'll call it a day. So Hamilton says, great, fine, success, yay for his client, who now has a defense against a charge of trespass. The next prong of his legal strategy, I think would be very familiar to a lawyer today, is to delay litigation or to settle out of court. Now, delaying litigation, the strategy here is, for Hamilton, ultimately, the solution to all of this is not to develop multi-pronged legal strategies and circumvent the laws. Ultimately, it's to change the law, because they're discriminatory anyway, so they should be off the books. But until that can happen, Hamilton advises his clients, when possible, to delay. Don't go to court. Try to do whatever you can to delay. But if and when that can't happen, settling out of court is obviously a better idea than going before a vengeful patriot-led jury who will whomp you with some serious damages. Next, private petitions to the state legislature. Here, Hamilton is thinking, if I can't outright change the law and affect everybody, maybe I can create an exception to the law for my client. So, case in point, he has a widow as a client who, during the war, New York State confiscated her family's land under the Confiscation Act, and over the course of the war, also this husband, who was deemed the enemy of the state, he dies. So now it's after the war, you have a widow with her children, a really sympathetic client. And Hamilton writes up this petition and gives it to the New York State legislature and says, here, I'm not asking you to change the law, but can you have mercy on this one really sad client of mine? And it works, and she does get some of her property back. Now, that kind of private petition, that of course doesn't solve the problem, and you can't do that with every client, but hey, when it works, that's what you do. He also exploits technicalities whenever it can help his clients, as you would expect. And his final prong to his legal strategy is the one that takes place outside of the courtroom. And I think Hamilton thought that this one was most important of them all, because this strategy was meant to change the law by convincing the people of New York that they don't like these kinds of laws, that they should want them off the books. So he writes some very public letters, published in newspapers, to the people of New York City, and as always, because he's Alexander Hamilton, he writes way too much and really should have a good editor to limit what he says, but nevertheless, he has some really great points in all of that prose. One of his points is, hey, did we really fight the Revolutionary War, getting rid of one tyrant, King George, just to replace him with another tyrant? The majority of the New York State legislature who wants to pass laws to discriminate against our people? That's not what this experiment in Republican self-government was all about. That's not what it means to put the rule of law above any kind of king. And his second point, I think, is probably more persuasive. His second point was about precedent setting, because he tells the people of New York, hey, if you're okay with this today, then you are setting the precedent for tomorrow, or the next day, or the next month, or the next year, or the next decade, when you are in the political minority, and now the political majority can deprive you of your rights, because you're okay with it now. So this is Hamilton's legal strategy, and he can be proud of it because he only has to stay at this for a few more years, and before Hamilton goes off to be the first Secretary of the Treasury, he can be delighted to see that New York State does actually change the law. By the end of the 1780s, these anti-loyalist statutes are either revoked or modified, and New York State has added an official Bill of Rights to the laws of the state. And the Bill of Rights does specifically say that all New Yorkers have access to the due process of law. So I begin with this episode to suggest that even at the beginning of Hamilton's legal career, he was very, very much interested in preserving rights and liberties. And this is a theme that goes through all of the rest of his professional career. And we don't usually think about Hamilton as rights conscious. We usually associate that with other statesmen like Thomas Jefferson, for example. But I'd like to argue that Hamilton does deserve to be known as a rights-conscious statesman and lawyer for this episode and beyond in his legal career. We shouldn't be surprised that Hamilton is interested in preserving rights and liberties, since he, like Jefferson and John Adams and James Madison, they're all trained as common lawyers. And so they're all immersed in this idea that English law provides rights and liberties. And he takes that seriously, now and later in his career. All right, so with that in mind, let us move to the next phase in Hamilton's legal career as the first Secretary of the Treasury. Now, when Hamilton goes to become the first Secretary of the Treasury, he has a lot of policy goals in mind. And I'm sure we're all familiar with them: assuming state debts, restoring the public credit, etc. But it is also part of his goals to be part of that foundational crew who creates a strong executive power, a strong executive branch. And when Hamilton thinks about what that means, to have a strong executive, he thinks independence, and he thinks energy. It's always the word he associates with the executive. And when he thinks energy, he thinks discretion. Discretion to act. Hamilton has in mind, when he's thinking of Washington and himself and the executive power, Hamilton has in mind an English institution, the English Justice of the Peace. The English Justice of the Peace is simultaneously a judge as well as an administrative official. At the same time that the Justice of the Peace will sit and hear cases that are civil or criminal in nature, the Justice of the Peace will also be in charge of a locality where he will have to administer taxes or repair infrastructure or even quarantine people if disease spreads throughout his locality. So Hamilton has that in mind, that executive power comes with that bit of discretion that judges have. And he helps to implement this discretionary power in the executive with something called the remitting process. Now, I will definitely explain what that is, but first, the story behind it. In January of 1790, Congress gets a petition from a British merchant named Christopher Sadler. And Sadler is writing to Congress because even though he's an experienced Atlantic world merchant, exporting and importing goods all over the place, this is the first time that he's come to the port of Boston since the new Constitution had been ratified and the new Congress opened for business and the new Congress passed all of the rules and regulations that make up the revenue laws. And part of those rules and regulations is that if you bring goods into port, there's all sorts of regulations about the paperwork, the kinds of ships, the way your cargo is presented. And if you violate those, there's all sorts of penalties attached, fines and forfeitures, etc. Well, Sadler comes into port, he doesn't know about the new laws, he inadvertently violates these new revenue laws, and his cargo is forfeited, it's taken from him. So he's petitioning Congress to basically say, hey, can you cut me some slack? I did not know about these new laws. I won't do it again, but I would really appreciate it if you could give me this pass just this one time. Congress does what it often does and just punts the petition to the nearest cabinet secretary, and that's Hamilton in this case. And Hamilton gets a hold of Sadler's petition, and Hamilton is absolutely mortified. And he's mortified because of what this means for his larger policy goals. So remember, Hamilton comes into the Treasury, and in his mind, the number one goal is to restore the public credit. How is he going to do that? Well, assume the state debts and then pay them off regularly, so creditors will have faith in the U.S. once again. But that requires tax revenue to be earmarked to go off and pay that interest and then later the principal on all those loans. But tax revenue comes in on the eastern seaboard at port. So, if Sadler's experience suggests that it's difficult to do business with the United States, well, that doesn't say anything good about tax revenues flowing in over the course of the rest of the year or years to come. So Hamilton is thinking this issue has to be addressed. So he writes back to Congress, and he says, with regard to Sadler, he says, definitely give him his cargo back. No fraud is intended. The guy just made a mistake. But Congress, I think that this is going to happen frequently. And because of that, we should vest somewhere a discretionary authority, someone who can, depending on the situation, remit or mitigate penalties associated with the revenue laws, just in case there's extenuating circumstances. Pause. Oh, and I think that should be me as Treasury Secretary. Well, in a world where Congress acts relatively quickly, it's not but a few months later, in May of 1790, that Congress passes the act that I refer to as the Remitting Act, otherwise known as an act to provide for mitigating or remitting the forfeitures and penalties accruing under the revenue laws. In certain cases, therein mentioned. The Remitting Act takes Hamilton up on his suggestion and vests in the Treasury Secretary a discretionary power to remit or mitigate any kind of revenue fines if he deems it fit. But there's a sort of added bonus to this remitting process. Congress also recruits federal judges of the district courts to act as the fact finders and administrators of this remitting process. So in other words, the remitting process sets Hamilton, the executive, up as the judge and sets the federal judges up as the administrators to collect the facts, transmit to Hamilton, and then implement whatever he says. The Remitting Act itself is relatively short, so I thought we could just look at some of the language of the statute. Here's part one. The said district court judge shall inquire in a summary manner into the circumstances of the case, and shall cause the facts which shall appear upon such inquiry to be stated and annexed to the petition, and direct the transmission to the Treasury Secretary. So, district court judge, you do all this work, but don't make a decision, because you got to pass that off to the Treasury Secretary, who shall have power to mitigate or remit such fine, penalty, or forfeiture, or any part thereof, if in his opinion the same was incurred without willful negligence or any intention of fraud, upon such terms or conditions as he may deem reasonable and just. So when I present this remitting process to my students, inevitably and always, they ask, well, gee, Dr. Brown, I can't believe that the judges stood for this. Don't they feel like their powers are being limited and some Treasury guy is getting their discretion? And the answer is no, they don't feel that way at all. If you look at this correspondence outlining the remitting process, where judges collect facts, send it to Hamilton, and he responds, you see that rather than having a relationship where judges are jealous of this power or dislike it or resent it, they collaborate with Hamilton. They work together. And the judges even develop different styles for interacting with Hamilton. Because some of the judges, take a very just the facts kind of approach, where they collect all the information, have the petition, send it to the Treasury, boom, all done. Hamilton makes his decision, end of story. But then other judges want to have a conversation with Hamilton, and they want to describe everything they're thinking as they detail all of these facts. And Hamilton, he takes that and he considers that too. And he'll even have a conversation going back and forth with multiple pieces of correspondence before Hamilton makes his final decision. But it's always Hamilton who makes the final decision. Now this process, which originates out of Hamilton's suggestion, outlives Hamilton as Treasury Secretary, because this remitting process remains on the books in some form at least until the 1820s. So that means that it outlasts Hamilton's tenure as Treasury Secretary as well as Hamilton alive here on this earth. And with all of the opportunity then for petitioners to petition the various Treasury Secretaries, inevitably you will get someone who does not like the ruling handed down from the Treasury Secretary, and they will challenge it. So you begin to see in the 19th century cases going to the district and circuit courts that challenge this remitting process. And the cases are challenging two things. First, the constitutionality of the process in the first place, i.e., what's the Treasury guy doing making this decision? And second, hey, I don't like the decision he rendered, courts, will you review it and overturn it? And whenever that happens, the courts always say the same thing. One, the remitting process is constitutional. It's totally fine for Congress to vest this bit of judge-like discretion in the executive. And two, what he says goes. As long as he's operating within the boundaries of the Remitting Act, we, the courts, cannot review his decision. So you're just going to have to live with it. So the Remitting Act process suggests, one, how Hamilton uses law to accomplish his particular policy goal, in this case the discretion in an energetic executive, and two, it demonstrates how Hamilton has this lasting impact on law because the process outlives him. And it's on that point that I would like to turn to our final episode of the day, which is Hamilton's legal legacy. And I think I'm going to surprise you with this one, because when you look at the judges and the lawyers who are quoting Hamiltonian jurisprudence after his death into the 19th century, they are using Hamilton, they are referring to Hamilton as an advocate for state sovereignty, for states' rights. Now, how could that be? Well, it all has to do with the idea of Hamiltonian concurrence, which I'll get to in a moment. But first, definitions. Two different concepts. And I recognize that here in Washington, D.C., in the Treasury building, everyone in this room probably has a good handle on both of these concepts, but just to be sure. The first definition is of federalism. Federalism is nothing more than the idea that under our Constitution, power is divided. You have a national government that has some power, and you have states that have power. And it is perpetually a question in law how to divide that power, where the power of one begins and ends, and what to do if they come in conflict. The second word to define is concurrence or concurrent power. And this is the idea that even in a federal system like ours, both sovereigns, the national governments and the states, can simultaneously and harmoniously exercise the same power at the same time. And the best example of this, Hamilton's favorite example of this, I'm sure everyone here who works at the Treasury, your favorite example of this, would be the power to tax. Because on April 15th, or whenever tax day falls, on that day, every American feels that concurrent power as they send off their return to the IRS and to their local state. For me, that's Kentucky. Concurrent power in action. Now, okay, so back 1788, when the US Constitution has not yet been ratified, Hamilton, of course, has the great idea, well, let's try to convince New York State, which has this real anti-federalist stream of thought running through it. Let's try to convince New York State to ratify this new document. And he and Madison and John Jay, they write the Federalist Papers. Okay, well, one of the major issues to address is the question of what about state power under this new Constitution. New Yorkers are concerned that, for example, you create this new Constitution that's all big and powerful with this national government, and now all of a sudden we can't tax like we used to. We're drained of revenue. We, New York State, withers and dies. We're concerned about that. Well, Hamilton writes in Federalist 32 that indeed there is nothing to fear, New Yorkers, because under this new Constitution, states will retain all of their pre-existing power that they had before. That's the takeaway. That's the thesis statement of Federalist 32. States, you have nothing to fear because you will retain all of your pre-existing power that you had before this Constitution is ratified. Okay, now on the face of it, you're probably thinking, well, that's definitely not true. And Hamilton knew it too. So that's why he said, that's my premise. However, there are 3 exceptions to this general rule. And I'm going to put the 3 exceptions up on the board in Hamilton's language, but I'm going to paraphrase because, like I said before, he says in 30 words what he could say in 10. So he says, okay, the thesis statement states you retain all of your pre-existing power, except 1. When the federal Constitution gives the power to the national government, and that power is supposed to be exclusive to the national government. States, you're not supposed to have this power. An example, the creation and maintenance of a US Army or Navy. New York should not be responsible for that. That's a national project. So states, you don't have that power. Exception 2 to the general rule that states retain their pre-existing sovereignty. When the Constitution specifically tells you, New York, that you lose a power. And for this laundry list, you just have to look to Article 1, Section 10 of the Constitution, and boom, you see exactly what you can no longer do. So exceptions 1 and 2 clearly stated in the Constitution. So it's exception 3 that all the lawyers are going to love because it's based more on context. Hamilton says in exception 3 that there will be occasionally, very rare, but occasionally, the instance where the national government is authorized to act. The states are authorized to act too, but depending on that particular context, both sovereigns acting creates conflict. A conflict that is contradictory and repugnant to the Constitution. And when that happens, in that rare instance, the state's power must give way to the national government's power. But you leave Federalist 32 with that premise in mind, that states retain their pre-existing authority. And even though in Hamilton's lifetime he does not do much to sort of expound on this, it's that argument that states retain their pre-existing sovereignty that's associated with Hamilton that lives on in state and federal case law after Hamilton's death. Because after Hamilton's death, all of a sudden we see these cases coming up where you have state power bumping up against federal power. And how are you going to resolve it? Well, jurists of the time, they're looking to Federalist 32. And so as an example of that, I'm going to end on my absolute favorite case to illustrate Hamilton's influence on law as well as the use of Federalist 32, McCulloch versus Maryland, which I bet so many of you in this room are like, oh yeah, I know this case. But I'm going to go through all the facts from the beginning to refresh your memories. Hamilton, as you know, as Treasury Secretary, has it in mind that one of the things this young nation needs is a central bank. So he writes his report, he gets his law, it passes through Congress, lands on President Washington's desk, and George Washington is genuinely conflicted about whether or not he can sign this central bank bill into law. So he calls Jefferson into his office and says, Jefferson, you don't like this bank, tell me why it's unconstitutional. And he pulls Hamilton into his office and he says, Hamilton, you tell me why it is constitutional. They do their things. Washington sides with Hamilton, no surprise. The bank bill is signed into law, and we have the first Bank of the United States. But that first Bank of the United States, in its charter, it has a sunset provision, which means that in 20 years, if Congress doesn't recharter it, the bank is gone. That's what happens. So in 1811, the bank shuts its doors, and what do we do next? We fight a war with Great Britain, where all of a sudden there's a new appreciation of how a central bank could have loaned the government money at a reasonable interest rate. And at the other end of the War of 1812, Congress and President Madison sign the second Bank of the United States, modeled after Hamilton's bank, into law. around the same time, Maryland wants to raise tax revenue. So Maryland passes a statute that says, okay, if you are a foreign corporation doing business in the state of Maryland and you're a bank, we want to levy a very modest tax on you. And a foreign corporation just means that you're doing business in the state, but Maryland didn't charter you. Well, the only bank that's a foreign corporation doing business in the state of Maryland in 1817 is the Baltimore branch of the Second Bank of the United States, and its branch manager, James McCulloch, refuses to pay Maryland's tax. So litigation ensues. And at every step of the way in Maryland state court, Maryland says, you're doing business here, you have to pay this tax. There's no reason we can't tax you. So finally, on a writ of error review, the case goes up to the US Supreme Court, where Chief Justice John Marshall presides. And the question is before him. Actually, two questions are before him. First, is the Second Bank of the United States constitutional? Washington had a crack at answering that question, but the question never went before a court. So now it's the federal court. Here's your first time to answer the question, is the bank constitutional? But the second question is even more interesting for us today, because the second question is, okay, if the bank is constitutional, can the state tax it? Well, the bank, McCulloch, they rely on Alexander Hamilton all day long, and we won't be surprised to hear that, because it's Hamilton, of course, who writes what basically amounts to a legal brief about why the bank is constitutional in 1791, and that's what the lawyers for McCulloch use now to argue the bank is constitutional. But I hope it surprises you to learn that the lawyers for the state of Maryland, they rely on Hamiltonian legal arguments even more, because they're using Federalist 32. And they point out that it's none other than Alexander Hamilton who makes the case that states retain their pre-existing sovereignty under this US Constitution. And guess what example he uses in Federalist 32 to make his case? The power to tax, which is exactly what's at issue here. So none other than Hamilton is already telling this. He's foreseeing the situation, and boom, we should be able to tax this bank. So Chief Justice Marshall, who is of course an old Federalist at heart, he has to decide between Hamilton and Hamilton. How is he going to do it? Well, as you know, he sides with Hamilton the nationalist. And he says, number one, the bank definitely constitutional for all the reasons Hamilton described. But on the second question, he says, of course, famously, that no, Maryland cannot tax the Second Bank of the United States because, of course, the power to tax is the power to destroy. And what he means by that is, in this instance, where the tax is very modest, it doesn't really harm the bank to pay it. But you could conceive of a world where Maryland wanted to stick it to the bank and tax them at some insanely high rate such that the bank can't stay open. And if that happened, you would have a state using its power to snuff out the constitutional power that Congress has to charter the bank, and we cannot let that happen. In other words, Marshall is saying that this is one of those instances of Hamilton's third exception, where in another world, both powers are totally fine on their own, but in this particular context, they bump up against each other and create a situation that's totally contradictory and repugnant. So I really love talking about McCulloch versus Maryland, not only because you get to see Hamilton's arguments in action as a state's sovereignty position, but also you just cannot talk about McCulloch versus Maryland without Hamiltonian jurisprudence on every page. He's all over this case, and in others in the early Republic, in antebellum years. So I hope I have convinced you to think of Hamilton as a lawyer today, and how important his legal thought was during his lifetime and beyond. And I can't wait to hear your questions. So thank you very much for being a great audience. Thank you.
So does anyone have any questions? everybody wants to ask a question. We'll get to you in a minute.
Hi, thank you for that
Hello.
lecture. I heard it in New York and it's even better.
Thank you.
I'm Nancy Spanis. I've written a book on Hamilton and economics called Hamilton versus Wall Street. And thinking about your argument, I was thinking that the first precedent that Hamilton made of there being a hierarchy of law is perhaps one of the most controversial contributions that he made in today's context, whether people see a hierarchy of law. Because obviously he used that concept for the Bank of the United States, that there's an inherent in sovereignty to be able to create a corporation for the good of the country.
Right.
In fact, for the general welfare, he even says. So I'm wondering if what you think about that.
Well, I think that when it comes to the constitutional powers of the federal government, if they have them, their power is supreme. That's a given because of Article 6, because Article 6 of the Constitution says so. But the very idea that you have a hierarchy of law in Hamilton's day, particularly in the 1780s, that is, as you said, it's very controversial. And scholars who write about judicial review, they are oftentimes pursuing a scholarship that's trying to find the origin of that idea of when a higher law trumps a lower law, and so far as you can plot that out going back in time, you're finding this origin of a concept which our current legal system absolutely adopts. It's why all sort of cases end at this US Supreme Court these days, because what they say will go, and if they decide to strike down a law, that's the law of the land, period. But that idea was controversial in the 1780s, particularly because even though the idea of a hierarchy of law, you can find it in English law, since we're doing something new here, and we have the people as sovereign, it's unclear that a higher law like the law of nations, something that the American people have no say in, would trump the will of the American people as expressed in statute. So that very idea of a hierarchy of law, it doesn't start with Hamilton, and it predates him for sure, but it's controversial, particularly in the American context of if the people are sovereign, and they didn't say anything about higher law, then can it truly trump what they do speak on, which would be manifested in state statutes. So controversial then, still controversial today in the sense, do we really want 9 people to be able to declare a law null and void, a law that comes out of a state? Well, I would say that's fine, and that's our system, but not everyone would. Okay.
I think most people know that Alexander Hamilton's law partner was Aaron Burr.
That Hamilton what in Aaron Burr?
Law partner in New York City was Aaron Burr. My question is, and I believe they became law partners early on, did Aaron Burr also get involved in these loyalist cases, and was the development of Hamilton's thought process, which you described brilliantly, something that was developed among the both of them, or did Burr have some of these ideas that he presented to Hamilton, or was this all Hamilton that Burr either followed or didn't because he didn't agree with it?
So, to the extent of things that I discuss in my book where I know that Hamilton is developing this because he's thinking about executive power and this is how he's implementing, no, Aaron Burr doesn't have a say. But that being said, there's all sorts of law, non-constitutional law, the law of, for example, marine insurance, of all things, that Hamilton does so much of his private practice in marine insurance law. And it's in instances like those kinds of suits in New York where, yeah, you're right, he's partnering with Aaron Burr on this case, but then on the next case, they're adversaries, where I don't know a specific example, but how can you not have your legal thought influenced by the people that help you to form your arguments or that challenge your arguments? So I think it's the New York legal scene definitely influences Hamilton. not always in the same ways that I'm describing in this lecture today, but I don't think it makes for good presentation material, so I don't talk about marine insurance, but that is his bread and butter once he leaves the Treasury. He does hundreds of marine insurance cases, and that has an effect not only on commerce in New York, but in federal law as well, because we're trying to stay neutral in the 1790s when he is talking about how to do business on the seas. So there's a lot of overlap here, and I definitely would not rule out Aaron Burr influencing his thought. I just could not tell you specifically. But not just Aaron Burr, other practicing lawyers in New York as well that he partners with.
One more question?
Yeah, my name's Ed Spanis. My wife writes about Alexander Hamilton. I write about John Marshall.
Okay,
And
dynamic duo there.
And the relationship between them. When you read about either Hamilton or Marshall, writers today will say, well, yes, they were for energetic government and big government, but they couldn't possibly have anticipated the regulatory state, the administrative state that we have today.
I agree with that.
Reading your book, I'm making my way through it, that really challenges that notion, it seems to me, because you describe sort of a hybrid process. The judiciary is doing administration.
Yes.
That the executive is doing judiciary functions. And it's sort of, the argument on administrative agencies is, well, they're hybrids, they do, executive, they do rulemaking, they do judicial, all these things. How can that be? It's unconstitutional.
Yeah.
What do you say to that?
Well, I definitely agree with you, and I really hesitate to ever answer any kind of question when someone says, well, what would Hamilton feel about today, XYZ topic? Because so much is different today than what Hamilton possibly could have imagined that it's hard to answer. But I do think everything you said I agree with, in the sense that yes, Hamilton, when he thinks about executive power, it's intermingled with judicial power. That does not mean that they're one and the same, but there's a lot of overlap that you might not imagine, particularly since we think, oh, these statesmen are all about separating power. Well, we separate our power differently today than they did. And so he accepts an overlap of executive and judicial power that, like I said, has a root in English law. The other thing that you said I wanted to comment on is the fact that Hamilton operates in the 1790s from a position of, I want the federal government to have power, but we're at the beginning and it has no power right now. So he was working to make it stronger from a position of weakness. We know the end of that story, where the federal government is hugely powerful today, and he just can't imagine that and doesn't. So it is part of my argument in my book that, therefore, in order to do stuff with law that Hamilton wants to do, he is actively involved in doing it in state courts, because the states have a lot of the power. The states are where you go first and foremost to get your government, not the federal government. So what we oftentimes confuse is Hamilton's absolute outright nationalism, big government all the way, is really, put into context, Hamilton trying to make the federal government live up to the potential of the Constitution when the states have all that power in the 1790s. They are coming. The states are coming from the position of power. And Hamilton's trying to sort of counterbalance that. So.
Great. Well, thank you, everybody, for coming in.
Thank you so much.
Thank you.
Thank you.